mandate as a legal command. You answered Justice Roberts' questions in a hypothetical, but I'm asking, are you accepting that hypothetical or that assumption, not hypothetical, I used the wrong word, assumption, or do you have, what's your best argument that it's not a command?
No, we're not, Your Honor. This court authoritatively construed 5000A and NFIB as not a command. It said it was a choice between buying minimum coverage as set out in sub A or making the alternative tax payment in sub B. That's an authoritative construction that Congress relied on when it amended the provision in 5000A. Congress did not clearly indicate that it wanted to depart from that choice construction. Rather, it relied on the choice construction, zeroed out the tax as a means of making the provision inoperative. And I think this is a critical point, Your Honor. Congress was entitled to rely on this court's authoritative construction, and we ought to give Congress the benefit of the doubt that it was doing what it said it was doing, preserving a lawful choice, rather than imposing the same command.
Counsel, I have no quarrel with, but why should we presume that a common citizen who wants to comply with the law would make that assumption?
Well,
or should make that assumption legally?
But, Your Honor, I think that to the extent that a common citizen is considering the intricacies of federal law, they would consider this court's authoritative and very prominent holding about this provision in NFIB. And, of course, they would also consider the very public and repeated pronouncements of the President and members of Congress who said we've gotten rid of the individual mandate and now you're allowed to freely choose what to do with whether to buy insurance.
One last question. If I understand your standing argument within this, involving the states, but are you arguing that the states are not harmed by the cost of more people enrolling in insurance as a legal matter, or is it that as a factual matter you think they have not yet demonstrated that they were harmed?
As a factual matter, Your Honor, we're on summary judgment. It was their burden to introduce specific facts showing that amended 5000A actually drives up their costs. They put in 21 declarations, but they didn't actually address that point.
So how do you deal with their argument that you had the burden of coming forth with evidence?
Well, I just don't think that that's consistent with precedent. It's the plaintiff's burden, that summary judgment, to establish that they have satisfied the requirements of standing.
Justice Kagan?
General, just continuing on this point of the state standing, I mean, why wouldn't it be right to say something like, look, you can expect that as a result of this law, more people will buy insurance, even when there's no enforcement mechanism. Just the force of law itself will encourage people to buy insurance. And Texas is now saying, well, that costs us money. It costs us money because of its effect on programs like Medicaid, and it costs us money because we have to send out these forms saying that you've bought insurance. I think that those are Texas's two arguments.
Well, Your Honor, we think under this court's precedents in cases like Lujan, that might be enough at the pleading stage, but that it wouldn't be sufficient at the summary judgment stage. But frankly, Your Honor, if we were misreading those cases, we'd be happy to lose on the issue of state standing and litigate this case on the merits, and then have Texas's rather minimal showing here set the bar for state plaintiff standing theories going forward. We just don't think that your cases allow it.
And why is that? What case doesn't allow it?
Well, I think it's just the general principle that a plaintiff must adduce specific facts to establish injury and causation, as the court indicated in Lujan, and that, we would think, would require something more than speculation or supposition.
And how about on the individual plaintiff side? This is going back to the Chief Justice's questions. I mean, why isn't, or why shouldn't the force of law itself, a person can say, if the law says I need to do something, then I have to do something. And that, we want citizens to be law-abiding. Why isn't that enough to create standing?
Well, I understand that point, Your Honor, but I think that that's contrary to what this court has said in cases like Poe. I mean, there the doctor plaintiff said, I'm looking at this law, it says that I can't give advice to my patient patient, and I think the law is unconstitutional, and it harms me because I'm not able to give this advice. And the court said, well, that's not enough. You also have to show a real threat of enforcement. So I think that would be a departure from what this court has indicated before, and it might open the door to quite a number of additional pre-enforcement challenges.
Thank you, General.
Justice Gorsuch?
Good morning, counsel. Let me pick up where Justice Kagan left off. As I understand it, the United States could still bring a civil action to enforce the mandate under 26 U.S.C. 7402A. Is that your understanding as well?
That's not my understanding, Your Honor. I think that this court made clear in NFIB that the only legal consequence of not purchasing insurance is the requirement to pay a tax, and Congress has repealed or zeroed out, rather, the tax. So there are no remaining legal consequences, and I just...
Let's just suppose for the moment that you're mistaken, and 7402A would allow a civil enforcement action. Would that change your view about the individual's standing?
Potentially, although I think what this court has looked to is not just the possibility of an enforcement action, but whether there is a real threat of enforcement. And here I don't see how they'd establish that because, of course, the federal government has indicated that there's no further requirement for individuals to purchase health insurance, at least at the highest levels of the executive branch. That's the signal that's sent out to the country.
So individual Americans would have to await an enforcement action before bringing a lawsuit challenging a federal statutory command?
Well, that's our understanding of your cases, Your Honor. But again, if we're misreading the standing cases, we're very happy to litigate this question on the merits because we don't think that they have any plausible basis for reading this as a command, and we'd be happy to have the court reach that question either at standing or on the merits.
And then with respect to the states, again, picking up on Justice Kagan's point, I thought I heard you agree that the theory of standing, that there's raised costs on enrollment-based injuries or compliance-based injuries could be enough to secure standing. It's just a failure of proof at the summary judgment stage. Is that a fair summary of your position?
Yes, that follows from Department of Commerce. States can establish standing if the predictable, if they actually identify specific facts showing that predictable choices by third parties are going to drive up state costs. But unlike the census case where we had lots of expert declarations and specific facts and detailed government memoranda showing that connection, Texas here has just not introduced any specific facts indicating that amended 5000A would inflict a concrete harm on the plaintiff state.
So if all we need is a substantial risk of a predictable effect of government action on the decisions of individuals, why isn't the Congressional Budget Office report stating that even after the penalty is removed, a small number of people will enroll because of a willingness to comply with the law? And it follows from that there will be increased costs to the states.
Your Honor, I think the CBO report from 2017 is probably the best thing they have going for them on state standing. We don't think it's sufficiently specific. It's a single sentence, and CBO didn't offer any data backing it up. And
do you disagree with it?
I don't think that we have any basis to agree or disagree with it.
So it's an uncontested fact in the record?
No, I don't believe that's right, Your Honor. It doesn't say anything specific to the plaintiff states, and it doesn't say anything specific to plaintiffs who are eligible for state health plans, so we wouldn't think that that's enough at the summary judgment phase. But again...
Justice Kavanaugh?
Thank you, Mr. Chief Justice, and good morning, General Mongan. To pick up on individual standing questions of the Chief Justice and Justices Kagan and Gorsuch, suppose Congress passed a law requiring every American who lives in a house to fly an American flag in front of the house. There's no penalty, and the question then is individual standing. Under Lujan, you're the object of the regulation as a homeowner. It's a forced acquisition of an unwanted good or service. Why isn't that enough to give you standing, knowing that some people are going to do that, buy the flags and fly them simply because Congress requires that?
Your Honor, I think if their theory was identical to what the individual plaintiffs advanced here, simply that, look, we are actively complying with this and it is causing us harm, that would run into a similar problem with the Poe line of precedent. But there may be some other legally cognizable injury, especially in the First Amendment context. And we're not disputing that plaintiffs can try and advance those types of theories of injury. We just don't think that they're substantiated under the circumstances of this case.
And on the CBO report that Justice Gorsuch mentioned, do you disagree that some people will follow the mandate and purchase insurance solely because of their willingness to comply with the law?
I don't have a basis for disagreeing with it or agreeing with it, Your Honor. I think it is unlikely, as the dissenting judge below noted, that individuals who wouldn't already take advantage of the very generous Medicaid programs or state employer health plans would do it solely because of an unenforceable command. But again, if we're wrong on that, it just brings us to their untenable merits theory that Congress has created a command that this court said was constitutionally impermissible, even as it was telling the American people that it was trying to get rid of or make inoperative this provision.
On the point that you mentioned that allowing individual standing here might open the door, are you aware of any other examples in the U.S. Code, at least, where Congress has enacted a true mandate, not something hortatory, but a true mandate with no penalties?
Your Honor, I'm not aware of that, and we don't think that's what Congress did here. We think that they just...
Yeah, I take that point. I was just wondering if you were aware of an example. On the merits of the claim, under NFIB, obviously it was justified under the taxing clause, but it now doesn't raise revenue. How do you respond to that point?
So in light of the NFIB construction, what Congress did here was to create an inoperative provision. It doesn't require anybody to do anything, and Congress has routinely created inoperative provisions. It's done so since the founding, and they haven't been viewed as constitutionally problematic because they don't alter legal rights or responsibilities or bind anyone.
Thank you.
Justice Barrett?
What should we make of the fact that Congress didn't repeal the provision? I mean, you said earlier repeal, and then you corrected yourself and said zeroed out. I mean, you're asking us to treat it as if it functionally has been repealed, but that's not what Congress did. Does that matter?
Your Honor, I think Congress understood how this court had construed 5000A as a choice, and it understood that it would make the provision effectively inoperative to zero out the tax. And that was a reasonable thing for it to do. Obviously, it was operating under reconciliation procedures that allowed it to make the change compliant with the Byrd Rule, and CBO had told it that there was no material difference between repealing the provision and zeroing out the tax.
Let me ask you another question that's related to some of the hypotheticals you've heard so far. You know, the Chief asked you about a mandate to mow the lawn, and, you know, Justice Thomas asked you one about forcing people to wear a mask. What if, in this case, you know, and as I understand it to be the case, you have to certify whether you've complied or not, and then the government keeps track of that. So the government keeps track of whether you wore a mask or whether you purchased health insurance. Does that change your view of whether there's an injury?
Well, I'm not sure that there is an ongoing certification requirement, at least in the tax forms, Your Honor. Perhaps that would change the analysis. But if we get to the merits, then I think that it's plain that this is not an operative provision, and there is no ongoing command. So even if that would establish standing, it wouldn't be enough to allow the individuals to prevail on the merits. And, Your Honor, I would like to just make the point that if the court were to disagree with us on the merits and hold that this is a naked command, then the only proper remedy for that would be an order making the provision unenforceable and holding that it's invalid. That would completely address the problem. What would be deeply problematic for the plaintiff, for the petitioner states, and for the rest of the nation is if plaintiffs were allowed to leverage this single inoperative provision to tear down hundreds of other provisions that Congress...
Counsel, but let me just return to the question on the merits. So the states have said these forms 1095B and C do require, as part of taxes, for one to certify whether or not one has maintained the minimum coverage necessary. Is that incorrect?
Well, Your Honor, the states do have to send out the forms. Those are required by separate provisions, and they serve continuing purposes related to the premium tax credit and the employer mandate that have nothing to do with 5000A. So those are costs that they would continue to have regardless of whether 5000A were on the books or not.
And individuals don't have to certify whether or not they've maintained coverage.
Well, the IRS website makes clear now that there's no longer an obligation on the annual tax forms to check the box regarding coverage. They've gotten rid of that requirement.
Okay, thank you, counsel.
Minute to wrap up, General.
Thank you. The plain intent of the 2017 amendment was to make 5000A inoperative and unenforceable, not to impose the very command this court said would be unconstitutional. And the current statutory framework makes clear that Congress wanted every other ACA provision to remain in effect if 5000A were unenforceable, because that's the precise situation Congress created. Respondents' inseparability theory would do violence to Congress's intent, invalidating hundreds of provisions that Congress chose to leave in place and that are functioning perfectly well without an enforceable 5000A. It would cause enormous regulatory disruption, upend the markets, cast 20 million Americans off health insurance during a pandemic, and cost the states tens of billions of dollars during a fiscal crisis. There's no basis for that result in text, intent, or precedent.
Thank you, General. Mr. Verrilli?
Thank you, Mr. Chief Justice, and may it please the Court. Respondents are asking this Court to do what Congress refused to do when it voted down repeal of the ACA in 2017. But their argument is untenable. The 2017 Congress did not convert Section 5000A from a choice to a command. The amended statute doesn't require anything of anyone. And even if one misconstrues 5000A as a mandate, it's not plausible that the same Congress that had just eliminated any economic pressure to purchase insurance nevertheless thought that an unenforceable mandate was so vital that its invalidation should doom the remainder of the ACA. There is just no way that Congress would have preferred an outcome that throws 23 million people off their insurance, ends protections for people with pre-existing conditions, and creates chaos in the healthcare sector. Respondents' arguments take constitutional adjudication as a game of gotcha to a whole new level. But this is not a game. This Court's precedents require respect for the constitutional role of Congress, and those precedents emphatically foreclose the outcome respondents seek.
Mr. Verrilli, 8 years ago, those defending the mandate emphasized that it was the key to the whole act. Everything turned on getting the money from the people forced to buy insurance to cover all the other shortfalls in the expansion of health care. And the briefs here on the other side go over all that. But now the representation is that, oh no, everything's fine without it. Why the bait and switch? And was Congress wrong when it said that the mandate was the key to the whole thing? That we spent all that time talking about broccoli for nothing?
So, Mr. Chief Justice, in 2010, I don't think there's any doubt that Congress made a predictive judgment about what would be needed to create an effective market, and they adopted a carrot and stick approach. And there were a lot of carrots. You know, the policies were attractive, limited co-pays, no annual or lifetime caps. There were generous subsidies to draw people into the market, and it was easy to enroll because of the exchanges. But there was also a stick, the tax payment if you didn't enroll. And I don't think there's any doubt that the 2010 Congress thought that stick was important. But it's turned out that the carrots work without the stick. That's the judgment that the Congress made in 2017. It's what CBO told Congress, that Congress asked the CBO, what will happen if we repeal the mandate outright? What will happen if we zero out the tax? And CBO came back and said, whether you zero out the tax or you repeal the mandate, the effects on the market will be the same. The market will remain stable over the coming decade. And if one looks at the amicus briefs filed by the health insurance industry, the Blue Cross brief, the AHIP brief, if one looks at the AMA brief, all those briefs are confirming that that judgment was correct, that it turned out that the carrots worked without the stick, brought enough people into the market to allow it to sustain itself. And, you know, Congress is allowed to learn from empirical experience in the world and adjust its policy choices, and that is what happened here.
General Mongan was asked about whether the burden on the state was enough to support standing. And of course, he had a little bit of a conflict representing the state, but you don't. Do you think that burden is sufficient? The paperwork burden, essentially.
No, Your Honor, I don't, because the paperwork burden flows from provisions other than Section 5000A, and so unless the court were to accept the standing through inseverability theory, I don't think there's a basis for finding standing on the basis of that injury.
Thank you, General. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, Justice Barrett asked whether or not just eliminating the penalty, the act wasn't changed, about the mandate provisions weren't changed, just the penalty was eliminated. So was that all that was necessary to eliminate the centrality of this and importance of this provision? Because when you argue that when this case came up, as the Chief Justice said some years ago, this provision was the heart and soul of the Affordable Care Act. And I know the assessment has changed, but the provision hasn't changed with the exception of the penalty. Could you explain why that penalty provision was so critical to the centrality of this provision?
Well, I think, Your Honor, this does go to the heart of the severability question, and I guess the argument that my friends on the other side are making is that the continued existence of 5000A sub A, even though it's unenforceable and there's no tax anymore, is still central to the operation of the Act, such that under the court's inseverability precedents, Congress would have preferred that the entire Act come down if that provision was struck down. And I think there are 4 reasons why that can't be right. First, you'd have to accept that the 2017 Congress said, we're going to eliminate any financial pressure to stay in the market, but the moral suasion is still so important that the entire law has to fall. And I just don't think that's a plausible account of what happened in 2017. Second, Congress asked the CBO what would happen if they repealed, what would happen if they zeroed out the tax, and the CBO came back and told Congress the effect on the market will be the same either way. In other words, there will be no material difference between zeroing out the tax and flatly repealing Section 5000A sub A, and that's the context in which Congress acted here. Third, the contemporaneous history is quite clear. The president, the congressional leadership, the bill sponsors, the committee chairman, they all were shouting from the rooftops that they were repealing the mandate and giving citizens complete flexibility about whether to purchase insurance. That is not what you would be saying to the world if you thought that moral suasion was essential to keep the system going. And finally, even if you thought that Congress really did have an interest in continuing moral suasion, that doesn't mean that they would have preferred to bring the whole ACA crashing down if 5000A were declared unconstitutional. In that respect, I think it's a lot like Celia law. There, in contrast to here, you had actual evidence that Congress wanted the CFPB director to be independent of the president. And here was just a hypothesis. There was evidence, but the court made the judgment there that Congress would not have preferred to see the entire CFPB come crashing down if that independence were eliminated. And I think that same kind of reasoning applies very strongly here.
Thank you.
Yes. Justice Breyer? Can you hear me?
Justice Breyer?
Yeah.
Thank you, Justice Breyer.
Yeah, I'm connected, I think. Question about the severability. Since at the time we heard, when this was first passed, that the mandate was absolutely crucial, as you pointed out, because unless people buy insurance under this mandate, the other provisions such as you don't have to worry about pre-existing conditions, etc., won't work. All right, why isn't that fact?
I'm sorry, Justice Alito?
Something happened. I'm sorry, my machine didn't work.
Yeah, I thought Justice Breyer was still on his time.
No, Justice Alito?
Oh, all right, well, Thank you. Mr. Worley, this does seem like deja vu all over again. But let me ask you this question about the theory of standing by severability. Suppose there's a very simple statute. It has two provisions, A and B. I am hurt by B. I am not hurt by A. A is unconstitutional. The statute has a clause that says if A falls, B falls too. Under those circumstances, would I lack standing to challenge A?
Well, that hypothetical definitely tests the limits of our objection to standing through inseverability, and I think it would be hard to maintain that position in the face of a statute like that. But what I will say, Your Honor, is this, that what it does point up, I think, is that if the court is going to validate the theory of standing through inseverability for the first time, that it ought not to do so combined with a presumption of inseverability at the standing stage, because even the situations like the one Your Honor's hypothetical describes are going to be very rare. Most of the time, as the plurality opinion in AAPC acknowledged, severability will be the outcome. And so if one presumes inseverability, even in cases like this one without an inseverability clause, then I think that is, as General Mongan identified, an open invitation to advisory opinions, because you're going to grant standing on the basis of the injury caused by provision B, hold provision A unconstitutional, and then say, but it's severable, and therefore the challenger doesn't get any relief. And so I think that's the problem. So I do think if the court really thinks that standing through inseverability is a valid theory of establishing Article III injury, that that ought to come with an analysis at the standing stage of the severability issue.
Okay, what you have said about what Congress thought in 2017 perhaps illustrates the difficulty of trying to identify anything that was thought by the majority of Congress other than what it says in a law. A lot of people, a lot of members in 2017 may well have thought that eliminating the penalty or the tax would not cause any harm and the whole act could continue to function well without it. But others who voted for it may have done so precisely because they wanted the whole thing to fall. So I don't know what we can make of what was done in 2017 along the lines that you've said.
So, Your Honor, I think that question points up the wisdom of the analysis in the AAPC plurality to focus on objective indications, statutory text and context. And beyond that, I would say, I don't think it would be an appropriate thing for the court to do to assume that there were members of Congress who actually acting in violation of their oath to uphold the Constitution by voting for a provision they knew to be unconstitutional in the hope it would bring the law down. I just don't think that's a premise the court ought to indulge in any case, and certainly not in this one. When applying the objective factors, what we know is that Congress zeroed out the tax penalty, which is a very strong textual signal that Congress did not think that 5000A sub A was necessary to play any significant role in maintaining these markets. And of course, the context here.
Justice Breyer, we apologize for the audio difficulties, and we'll go back to you.
Oh, that's all right. It's not a problem. Go ahead.
Good. Justice Sotomayor?
Counsel, am I assuming your answer to be that given a choice between, or among, because there could have been many choices, between invalidating and the entire ACA and just zeroing out the tax, that the 2017 Congress's choice was to just zero out the tax, correct?
Yes, that's manifest on the record, Your Honor. There were efforts to repeal the entire ACA. Those efforts failed in the Senate. They were voted down. So we know that that effort to repeal the entire ACA was voted down, and the only change made was the zeroing out the tax in 5000A.
And so if the choice is, yet again, after NFIB, declaring the individual mandate unconstitutional, if one sees it as a command, the 2017 Congress has already told us that it doesn't want the rest of the act to fall, correct?
That's certainly our position, Your Honor, and that and it just would be utterly inconsistent with everything Congress had before it, with the judgment Congress made, and with the wide announcement to the public that this amendment effectively repealed the mandate.
Counsel, there's an intuitive feeling that if the individual mandate is struck down with respect to standing in the states, that they would have less reporting cost because, or less enrollees in their Medicaid and CHIPS program. That's their argument about standing, correct?
That's their argument, but aside from inseverability, that's the only direct injury they claim flows from 5,000.
Would you address that argument? Your co-counsel for the state seems to say there's no evidence that that's true or false. But I thought many of the briefs showed that it was a faulty premise for other reasons. Do you agree with that?
Yeah, I mean, there's definitely no evidence. General Mongan went through that. That's correct. It was summary judgment, and under Lujan, they had a burden. They didn't meet it. But apart from that, basically their argument, I think, boils down to what they claim is common sense, which is that, look, people are going to read this mandate and they're going to enroll, and that in Medicaid to satisfy it. But, I really think it's the opposite of common sense. I mean, the theory here is there were people out there who weren't enrolled in Medicaid before when the mandate was accompanied by a tax consequence, and therefore were subjecting themselves to the tax consequence. Congress amends it, gets rid of the tax consequence, and those people say, oh, well, Congress got rid of the tax consequence, but look, there still seems to be a mandate, so I'm going to go enroll in Medicaid now.
Justice Kagan?
Mr. Borelli, I understand your view that the empirics of how this law works have changed since 2010 or 2012, but we still have some relics of the old view, which is that the individual mandate was the key to everything, some relics of that in the law. And I'm pointing specifically to what the plaintiffs in this case sometimes call the inseparability provision, which is a finding, basically, that the mandate was essential to creating effective health insurance markets. And I guess I'm wondering, what do we do about that, the fact that that finding still exists in the law? Does that constrain us in any way?
Well, it's clear that I think that it doesn't overcome the strong presumption of severability because it's not an inseverability clause. Now, if the Section 18091 had said, if Section 5000A is declared unconstitutional, then 42 S.C. 300 GG shall be deemed inseverable. Those are the insurance protection provisions. We'd have to make an implied repeal argument. I think we'd have a strong one, but we don't need to make that because the finding is not an operative provision of law. It's just a finding. And I think what's key is that what it expresses is the 2010 Congress's view about the state of affairs that existed in 2010. As a textual matter, the provision is addressing Section 5000A as it was originally enacted in 2010. That is the insurance, the mandate to purchase insurance backed by the tax. Now, the argument, my friends on the